Good afternoon, everyone. Welcome to our webinar, How the Supreme Court Affirmative Action Ruling May Impact Your Nonprofit's DEI Policies and Mission. I'm Daryl Maxwell, Director of the DC Bar Pro Bono Center's Nonprofit and Small Business Legal Assistance Team. Let me first say thank you to my colleague, Lauren Paley, for all of her behind-the-scenes handiwork and logistical support for running this program. Let me also say thank you to those of you who shared questions that helped us shape some of the discussion we'll cover today. And of course, let me thank Tristan Morales, our presenter for today, a partner at O'Melveny. Just a couple of logistical questions to lay the foundation. This session will be recorded and is being recorded right now. You can find a copy of today's presentation in the chat section of the GoToWebinar program you're using to listen. For any questions that you have, please use the questions function. There's a question box in GoToWebinar. For the purposes of this training, questions should be fairly general and not seeking specific legal advice. Now on to today's topic. Discussing the legal landscape for DEI and affirmative action. Nonprofit organizations recognize the value of diverse perspectives and the imperative of aligning decision-making processes with their core values. Unfortunately, today's DEI landscape can be fraught with legal and reputational risks. Recent court decisions have emboldened some well-coordinated advocacy groups to target DEI initiatives. We've enlisted the help of our longtime friend, Tristan Morales, a partner at O'Melveny, and a longtime Pro Bono Center volunteer to help us best understand the legal landscape and best practices for protecting your organization. Tristan, I'm going to turn it over to you.
Thank you very much, Daryl, and thanks to Lauren, and appreciate the opportunity to be here today with everyone. As Daryl mentioned, I'm a partner here at O'Melveny in DC. And we've been working in this, very much evolving landscape over the last 15 months or so. The Supreme Court's decision, which we'll talk about briefly in a moment, was just about a year ago. And we launched a working group a few months before that decision, with the idea being that we wanted to think ahead outside of the higher education context for how a ruling in the higher education context might impact our clients, both on the employment front, but also with things like contracting decisions, supplier diversity decisions in the nonprofit world, with grants, both where you're applying for grants, receiving grants, distributing funds. We really wanted to kind of think ahead and see what the landscape looked like. Over the last year in particular, it has very much been a in progress, rapidly developing landscape, and part of what we wanted to do today was to share a little bit of the insights that we've picked up in terms of both the sort of cases and complaints that are moving their way through the court system and through the public, in terms of highly publicized Twitter complaints or complaints for requests for investigation that are going to state, local, and federal governments, but also some of the initial decisions that we've seen where courts are trying to map out what the decision last year in the Harvard and UNC case means for employers, nonprofits, and other organizations. So this is a slide that we'll come back to at the end of the presentation today, but I wanted to offer just as sort of a preview of some of the areas of policies that I intend to discuss. Some of these came up in some of the helpful questions that some of you all presented before today's discussion, and I can tell you that they are categories of initiatives that come up frequently, both in discussions with clients. I think any law firm that's working with clients would point to an area of categories of initiatives like this as sort of common areas of interest these days, but also that courts are grappling with, that state, local, and federal government entities are grappling with as well. You'll see that these primarily focus on the role of an employer, which I know is relevant certainly to all organizations, but they also include in the bottom right there things that go beyond the employment relationship. So, we often think of the DEI lawsuits that are in the news as, the role of a hiring decision or goals for senior leadership in an organization, affinity groups, fellowships, things like that. That is part of what we'll discuss today. But there's also been quite a bit of attention to what's called here contracts/partnerships, which is this sort of broader set of contractual relationships, not necessarily limited to employment, things like who you partner with in terms of grants or for suppliers or vendors, or a wide range of sort of contracting opportunities and partnerships, and how those have been folded into this legal landscape in recent months. So like I said, you'll see some of these policies kind of filtered through some of the cases we'll talk about today, and I'll return to these at the end of the discussion. But thanks for the number of questions that we received that are embedded in a number of these categories of initiatives. So I think the place to start is with the Supreme Court's decision. As I mentioned, it was just over a year ago. It was a higher education case. I'm sure all of you have heard to some extent about the court's decision in that case, but it involved two affirmative action programs in the higher education context. One was at Harvard College, the other was at the University of North Carolina. In both admissions programs, in terms of what the programs were at the time the court was deciding the case, race was one factor among many that the admissions offices could consider in making employment or making admissions decisions. So both Harvard and UNC, in describing their programs to the court, said that there were many factors considered when they looked at an application. They would look at the testing, they would look at the applicants' essays, they would look at their extracurriculars, but under their prior programs, the race of the applicant also was, at least to some extent, a factor that could be considered in making an admissions decision. The Supreme Court, in the decision about a year ago, said that that was impermissible, that under the federal Constitution, making admissions decisions that turn on an applicant's race are unlawful. That has set in motion this sort of year of trying to map out what that decision means, both in the higher education context and more broadly. There are a couple points about the Supreme Court's decision that I'll highlight, including because they've had an impact on what courts have been trying to sort of think through outside of the higher education context. The first is the court in the Harvard and UNC case was very focused on the idea that an admissions process is zero sum, that if race is used as a plus factor in support of certain candidates, that it will inherently be a negative for other applicants by virtue of the fact that there's a limited set of admissions slots at a university. And the second was the idea that the programs, to the extent that they allowed race to be used as a plus factor, did so, and this is the court's terminology in that second little bullet you see in the section at the bottom, did so on the basis of race for race's sake. The court's discussion of that was about the idea that rather than an individualized assessment of an individual's cultural experiences or ancestral experiences, that the existing programs at Harvard and UNC made it so that a candidate might receive what they called a plus factor in the admissions process based simply on a box that they had checked in terms of their race or ethnicity. And the court viewed that to be an insufficiently individualized inquiry and one that was operating on the basis of race for race's sake. The reason I highlight that language is because the court contrasted the race for race's sake concept in a latter part of its decision. And this has probably been the most highly sort of scrutinized and reviewed section of the court's opinion, or at least one of them. So this is a highlighted language and a couple passages from the end of the Supreme Court's Harvard and UNC decision. And what the court said here was, they had already laid out what was unlawful, And this was a section of the opinion that said, here are some things that you can keep in mind as to what may be lawful or what can be lawful when you're thinking through an admissions process. And the court says at the top, nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life, be it through discrimination, inspiration, or otherwise. And it continues at the bottom, a benefit to a student who overcame racial discrimination, for example, must be tied to that student's courage and determination. In other words, the student must be treated based on his or her experiences as an individual, not on the basis of race. Like I said, this was highly scrutinized from the moment the decision came out, with universities trying to figure out what the court was saying was and was not permissible in the admissions context. And it has been equally scrutinized and focused on by courts and employers and organizations outside of the higher education context. And it's a concept that you'll hear me talk about in the context of a number of decisions that we'll walk through today. So the higher education decision we just talked about was a higher education decision. It was not an employment decision. It was not a decision about nonprofit law or contracting law per se. But there have obviously been ripple effects outside of the higher education space. And the ripple effects have included a large number of suits that have been filed or complaints that have been publicized over the last year or so, alleging that principles taken from the Supreme Court's decision last June support the idea that other programs are unlawful. So the allegation is that an employment policy might be unlawful, or a nonprofit policy, a contracting policy, and often those claims in the last year or so have cited to the Harvard and UNC decision. But in terms of the actual law that has been front and center in those cases outside of the higher education space, there are two federal laws that have received the most attention. Those are the two that are on your screen here. Title VII is probably the most well-known employment discrimination law. It's the federal non-discrimination law that applies to the employment context. And so when you hear the basic foundational principles that it's unlawful to make a hiring decision, for example, on the basis of race, to discriminate against someone in a promotion decision, that's typically traced to Title VII, the first prong here. It's impermissible under federal law, under Title VII, to discriminate on the basis of race, sex, religion, and certain other protected categories with respect to the terms, conditions, or privileges of employment. So broadly speaking, the employment relationship, hiring decisions, promotion decisions, but it can be a broad range of other sort of terms, conditions, or privileges of the employment relationship. The second and third prongs here have been mentioned in some of the recent complaints over the last year or so. They often receive less attention, there are fewer cases, but the second and third prong I wanted to put up on the screen because they have been noted in some of the complaints that have been publicized. These are also part of the same federal law. So limit, segregate, or classify employees or applicants in a way that would tend to deprive any individual of employment opportunities or adversely affect their status as an employee based on a protected category. That's a second provision in terms of what Title VII makes unlawful. And then the third prong there is about apprenticeship or training programs. Again, this concept of discrimination on the basis of protected categories, such as race, being impermissible. The third prong there discusses that concept in the context of apprenticeship or other training programs. The second federal law at the bottom of the screen is Section 1981, which again had over sort of a longer historical timeline been less front and center, less prominent in discussions of non-discrimination in federal law, but has received a lot of attention in the last year or so. And Section 1981 provides that it is unlawful under federal law to discriminate on the basis of race in the making and enforcement of contracts. So contracts is the key word there. It is, generally speaking, a broad term And the idea of Section 1981 is in some sense broader than Title VII, because Title VII is limited to the employment context, whereas Section 1981 includes contracts more broadly. So for example, a vendor contract, a supplier contract, things like that may be subject to Section 1981's race discrimination, non-discrimination obligation. But Section 1981 is in some sense narrower than Title VII because it is only about discrimination on the basis of race. So Title VII includes, as noted at the top of the screen, other protected categories, sex, religion, etc. Section 1981 is about race discrimination in the context of contracts. So what we're going to do today is talk about a couple cases that sort of play out what the claims have been and what the courts have found in some of these Title VII and Section 1981 cases, and how those might apply to you as a nonprofit organization. Couple of last points about these two federal laws. There is no exclusion for reverse discrimination claims under either of these federal laws. So in other words, both Title VII and Section 1981 include a general prohibition against discrimination on the basis of race, and that discrimination applies with respect to discrimination against or in favor of any race, quoting that 1976 decision McDonald, which you see at the top of the screen there. So you know, there's no sort of different bucket of law entirely, or no exclusion that applies if the claim is asserting a so-called reverse discrimination claim. There is just the general principle that's stated under Title VII and Section 1981. And then the last note is, you know, we talked about affirmative action in the context of higher education with Harvard and UNC. There is a affirmative action doctrine in the employment context and potentially more broadly that also dates back to the 1970s, but there is some question about whether or not that affirmative action doctrine will change in shape or in terms of you know, how it applies in light of the affirmative action decision with the Harvard and UNC cases. And there are other specific requirements that have long applied under this voluntary affirmative action doctrine outside of the higher education context. So the Fearless Fund case is the first one that we'll talk about today. I think it was the first question we received, and it's gotten a lot of national press, it's gotten a lot of attention, and it involves a nonprofit, so you may be quite familiar with the Fearless Fund decision. This is a case that involves a contest offered by the Fearless Foundation, which is affiliated with the Fearless Fund, an Atlanta-based venture capital group. And Fearless Foundation has, for a number of years, offered a contest to provide grants and business support services to Black women-owned businesses, including a monetary award. In the Fearless Fund case, there was a lawsuit brought by an organization on behalf of unnamed members who said that they wanted to participate in the contest, but they were not eligible because they're not a Black women-owned business. That organization who filed the suit alleged that the program violated Section 1981, which we just talked about, because it had eligibility restrictions that limited participation in the contest on the basis of race. There have been a few court decisions over the last year or so sketching out the court's ruling in this case, but in the last couple months, there's been a decision from the Federal Court of Appeals, so the highest court that would hear this case unless the Supreme Court decides to take the case on. And the Court of Appeals made two judgments that are most relevant for this discussion. One is they found that the contest at issue was a contract under Section 1981. So you'll recall that that's the core term at issue in Section 1981. One of the questions was whether this contest was a contract, including there was some discussion about, you know, this is a nonprofit, a foundation that's offering this contest. Does that impact the analysis of whether this is a contract? And the court here said it's a contract. Contract, broadly speaking, means, there's something being offered in exchange for something else. Here, participants can apply to this contest. They agree to certain terms to be an eligible participant, and if they prevail, they get awarded, a grant and business support services. So that's a contract. So what does that mean? It means you then turn under Section 1981 to deciding whether or not in that contracting process there was race discrimination. And the court in this case said because there was a race-based exclusion of applicants, i.e. the contracting opportunity was only available to Black women-owned businesses, that the program is likely to discriminate under Section 1981. The two other issues that are on the screen there got a lot of attention in the decision as well. There was a discussion about whether or not the foundation had essentially an expressive interest, a First Amendment interest in limiting eligibility for their contest to Black women-owned businesses because they wanted to express support for those businesses. The court said you can't, in the court's view, make limitations on participating in a contract on the basis of the expressive interest that the foundation was asserting. In other words, that it wasn't sufficient for the organization to say that they wanted to provide an expressive message. If the contract was limited in a way that was racially discriminatory, then that meant the program was, in the court's view, unlawful under Section 1981. And then the last item on the screen there was this sort of unique part of the case where there was not actually a lawsuit filed on behalf of, three people that were named. There was instead an organization that filed the suit. They asserted that they represented unnamed people who wanted to participate in the contest, but they were only identified as, member A, for example. And the court said, although that's sort of an unusual way to bring a suit, at this kind of stage of the lawsuit, it was sufficient that they had identified certain members who supposedly wanted to participate in the contest but were ineligible because of the limitation in terms of eligibility to Black women-owned businesses. So that's the Fearless Fund case. It's gotten a lot of attention because it is a high-profile federal appeals court. It's one of the first cases that is discussing what Section 1981 means after Harvard and UNC. And it also has gotten a lot of attention in the nonprofit world because it involved a foundation and some of these issues about, whether the analysis changes in the nonprofit world. The Fearless Fund Court has suggested that contract means contract and that, there isn't a categorical carve out for nonprofits from the non-discrimination mandate in Section 1981. One of the things I want to do with this case, and then I'll do with a few of the other cases I want to talk about, is okay. This is the the ruling on the law, and it's an important ruling. What are some of the things that organizations are doing to try and think through how they might adjust their own eligibility criteria or their own programs if they want to sidestep the legal risk issues that are front and center in Fearless Fund. A couple of examples that I'll provide, and these are not things that I'm aware of that Fearless Fund has done here, but sort of broadly speaking, what are organizations doing? What are we seeing organizations in some contexts consider doing in response to lawsuits filed like this? One example is organizations that are changing eligibility criteria from what used to be, perhaps race or gender-based eligibility restrictions to things like first-generation professionals, right? So instead of a program, and this sort of starts with a consideration of the college and university context, right? When the Harvard and UNC case said, okay, certain universities had race-based affirmative action programs, those are no longer lawful. What are some of the things that colleges and universities started thinking about in terms of things that they might shift those admissions programs to? First generation college was a very common discussion point. So instead of a plus factor in the admissions process based on race, universities could start considering, okay, there's a plus factor in the admissions process if you're the first student in your family to go to college. And I've seen organizations outside of the higher education context consider something similar. So instead of eligibility for a contest or for support services being limited on the basis of race, you might see an organization say, eligibility for our program is limited to first-generation professionals. And you might pair that with a statement that says, to make clear, eligibility is not limited on the basis of race or gender. So in other words, anyone can apply without respect to race or gender, but there might be an eligibility restriction for first-generation professionals, because that's consistent with the mission of the organization. In that example, because the eligibility criteria is not limited on the basis of race or gender, the idea is that it avoids the issue that was raised in the Fearless Fund case with an express eligibility criteria. Another example, you might see an organization that's shifting their eligibility criteria to something like, we want candidates who've shown a demonstrated commitment to their local community, and that can be tied to your local community. So this Fearless Fund involved an Atlanta-based venture capital fund. We've seen organizations in places around the country consider something like, candidates should be prepared to discuss their demonstrated commitment to the Atlanta community, or their demonstrated commitment to their local community. So the idea is to shift from eligibility restrictions that are tied to identity, the identity of the applicant, and are instead focused on the individual experiences, right? Their demonstrated commitment. What work have they done with their local community, or it can be kind of identity components that are not tied to race and gender, with the example of first-generation professionals, just like first-generation students. So that's Fearless Fund. Again, that's a Section 1981 case. There will be more potentially to come in this case, but there's been a high-level federal appeals court decision, and it's gotten a lot of attention, particularly in the nonprofit world. Another very recent Section 1981 case that I wanted to talk about is Newsyard versus the Minority Business Development Agency. I know that one of the things that came up in at least one of the questions was, what impact will these DEI cases and the Harvard UNC case have on federal grants? If you're applying as a nonprofit for federal grant money, and then on the flip side, if you're offering grant money or partnerships or support funds, what might be impacted from this emerging legal landscape. This Newsyard case is one of a couple recent decisions that involved government agencies, and the MBDA, so the agency here, provides grants and services. It's a federal agency, and they have a offering that is tied to candidates who are socially or economically disadvantaged individuals. So their services are offered to individuals who meet that criteria. And the agency had long applied a presumption on the basis of race. So if the candidate was of one or a number of racial groups, they got an automatic presumption that they were considered disadvantaged for purposes of the grants and service criteria. They were eligible on that basis without having to do an individualized showing of their social or economic disadvantage. So that was challenged. It was challenged, I think, by individuals who didn't meet the automatic presumption, but said that they were otherwise interested in getting the grants and services. And the court in this case said that the federal agency's racial presumption, to use their terminology, was unconstitutional. And I've quoted, there's some language in here that's gotten attention for what the court decided, but the court basically said what the agency was doing was applying a presumption that is not individualized. It's a presumption that someone that fills out a box in the application process, if their application is one of the the racial groups that's been deemed for this automatic presumption, then they're considered socially or economically disadvantaged automatically without a further review of their application. And the court says that existing program meant that people were being considered disadvantaged quote, without regard to the life circumstances, financial performance, or any social or economic metrics for the individual applicant. And then they gave an example. They said, under this approach, that means that Oprah Winfrey is presumptively disadvantaged, while, and then they contrasted it, a candidate that is applies from Afghanistan, Iran, Iraq, or Libya is not, because they're not a member of a qualifying racial group. And it's a lengthy opinion, but this is sort of the discussion where the court says, you know, kind of looking back at that highlighted language from the Supreme Court's decision in Harvard and UNC that we talked about at the beginning, what this court says they think has to happen after Harvard and UNC is there has to be a more individualized assessment of a candidate's application instead of, you know, an automatic presumption or a plus factor, to use the Harvard and UNC concept, and that has to look at the individual life circumstances, you know, social economic metrics, essentially the lived experiences of an individual applicant. So again, what does that mean in practice, and what does it mean in terms of, you know, if you're an organization thinking, how can that potentially inform what my, you know, eligibility criteria are if I'm offering grants, or what my application might look like if I'm applying for federal grants. And the clear trend that we've seen from the federal agencies, the MBDA, and then there was another Small Business Administration grant program that went through similar litigation, is a shift to a more narrative-based eligibility process, right? So instead of kind of an automatic presumption on the basis of race, there's been a shift to now candidates will get a question, and the question will have a prompt that says, you know, describe your life experiences that qualify you as a, you know, socially or economically disadvantaged individual. And there may be 500 words or whatever it may be. But the idea is that these agencies are shifting to a more individualized narrative-based approach as opposed to an automatic presumption. One of the interesting things when the first of these kind of shift toward narrative applications happened at an agency, and it was the Small Business Administration, is a lot of the practitioners who work with, you know, clients, who work with organizations to apply for these government contracts or these government grants were saying, you know, this is going to create an administrative, a huge administrative burden. You know, they get thousands of applications. They're now going to have to read essays, and, you know, they're going to be, you know, small businesses or small organizations having to write essays. And the sort of commentary in the public press was essentially like, yes, that's correct, but, you know, this is where we're headed. Essentially, you know, the agency seemed to kind of be signaling like, we haven't solved that administrative burden problem, but our read of where the law is evolving is, you know, we have to shift to a more narrative-based approach. And so I think that'll continue to kind of evolve over time, but that narrative approach has certainly been something that has been a trend. And again, to go back to that highlighted language that I talked about at the top from the Harvard and UNC case, you know, recall that there's the discussion in the court's opinion that says, you know, someone that writes an essay, if they refer to their, you know, to their cultural background or their, you know, racial background in terms of an experience of overcoming adversity due to racial discrimination, that's not automatically something that the person making the selection decision has to not consider. That can be considered so long as it's considered based on the individual's experiences rather than, you know, race for race's sake, to use the Supreme Court's terminology. So again, broadly speaking, I think there's been this sort of, you know, movement towards a narrative-based focus, individual experiences that doesn't necessarily rule out by any means, you know, a candidate discussing their lived experiences in terms of overcoming discrimination or adversity, but it is a different model that some of these organizations like this agency are shifting to. So the next category of Section 1981 complaints, and these, again, you may have seen, because although they all involved law firms, there was quite a bit of press, particularly last summer, about some of these Section 1981 complaints. These were complaints that involved law firm fellowships, so typically a summer program where law students, you know, come in for a 10-week period or 8-week period, and have an opportunity to work at a law firm, a number of firms offered fellowships, and there were lawsuits filed alleging that the eligibility criteria for those fellowships were restricted on the basis of race and gender. Most of these cases were resolved quickly with an announcement that the law firm had revised their eligibility terms for the fellowship. There would be typically a statement that the eligibility going forward for the fellowship would not be limited on the basis of race and gender, and that was typically part of an early kind of quick resolution of these lawsuits. There weren't, extensive briefs filed or decisions from the court or things like that. I've included here again the same thing we've kind of done with a couple of these early cases. What does that look like in practical terms? What does the new revised eligibility language look like in these examples that I'm talking about with the law firm cases? And I've quoted two of the examples where the new language was rolled out for a fellowship program. So one of the law firm programs was revised to say that the firm was looking for candidates with a demonstrated commitment to promoting diversity, inclusion, and accessibility. So the idea was for candidates to describe that demonstrated commitment through kind of a narrative-based description of their, of their experiences, of their resume, et cetera. A second example was, a firm that said that their eligibility criteria was focused on candidates with a demonstrated resilience and excellence on their path to a career in law. So again, a more kind of narrative-based focus. And again, you can see how concepts like this are being considered and utilized outside of the narrow context of law firm fellowships. It's some language that an organization who's offering a grant or applying for a grant might talk about their organization or their experiences using similar descriptions: resilience, excellence, a commitment to diversity, inclusion, accessibility. The main thing there in terms of the difference, how these programs were described, is it's clear that there's no eligibility restriction just based on someone's race or someone's gender. Any candidate is eligible to apply and to describe their demonstrated commitment to promoting diversity, inclusion, and accessibility, or their resilience and excellence on their path to a career in law. So those are the Section 1981 cases of particular note, again, focused on this idea of contracts, which has been used to sort of raise claims in the nonprofit context and more broadly. I want to talk about a couple of Title VII cases. So again, these are the federal employment discrimination law cases. This is another, pretty recent decision. The Fourth Circuit is the Federal Court of Appeals for a part of the Mid-Atlantic, including Virginia and Maryland. And this was a case I highlight for a couple reasons. One is, I think over time everyone has gotten familiar with the idea of discrimination complaints that are filed under Title VII. Someone who doesn't get a promotion or doesn't get a new hire position, or alleges that there's been a disparity in how much they're paid, or in when they were laid off as compared to another candidate. Those claims for a long history have been presented under Title VII as employment discrimination claims. One of the things that we're seeing in the in the DEI emerging legal landscape is some of those same theories being used to bring cases that are brought by candidates who are alleging that the DEI policies at an organization or at a company are discriminatory on the basis of race or gender. So in essence, they're very similar in terms of how the complaints are packaged, right? It might be a candidate that says, there was a promotion opportunity, I was candidate A, candidate B got the position, and my allegation is the reason that candidate B got the job was because of race. There's a long history of complaints alleging that, a candidate, a black candidate was denied a position on the basis of race, or a Hispanic candidate, or, a woman alleging that there was gender discrimination. We're seeing very similarly kind of packaged cases now but they fit this sort of reverse discrimination model. And this Duval case is an example of that that's gotten a fair amount of attention. This was a case where there was a pretty senior executive at a company. The executive didn't get a promotion and then was ultimately separated from the company. And the allegation was that the reason that he was terminated was because the company was very focused at the time of the promotion decision or the termination decision on certain DEI goals. And so I'm quoting language in this slide from the complaint, from the lawsuit. And the individual Duval said that at the time there was, quote, a wide-scale D&I initiative at his company at Nuvant, including diversity targets based on race and gender. So, the first thing he did in the lawsuit was to say, here are all the things that the company was saying publicly about, its goals for senior leadership at the organization. Here are specific goals that the organization has set for, the C-suite, for the senior most executives at the organization in terms of race and gender. So that's kind of looking at, public materials and alleging that those support this inference that, the hiring officials or senior executives at the company were considering race and gender when making employment decisions, in contravention of Title VII. But then the second thing that he did, there's a reference here about changes to the executive team, is that when this case went to trial before a jury, which it did, the individual who brought the suit, Duval, didn't just focus on what the company had said in their public materials or what was on the website about, goals based on race or gender, but he also, outlined, okay, at the C-suite, here is the year-over-year data in terms of representation based on race among senior executives or representation based on gender. And he alleged that data supported this inference that when employment decisions were being made, that race was being considered or gender was being considered in the employment decision, which again, going back to our discussion of Title VII at the top of this discussion, is generally impermissible. The jury agreed with the plaintiff that race/sex, which are the protected categories at issue under Title VII, were a motivating factor in the termination, so that they were, part of the motivation, at least, for why this individual was terminated. The jury concluded was on the basis of his race and gender, and it was sort of against this backdrop of, testimony and evidence that he put on saying that there was discrimination in the hiring process because he was a white male at the company. There was a substantial verdict, a damages award in that case, which is one of the reasons that it's gotten a fair amount of attention. Again, the number that you see there, the $3.8 million number, that's really a factor of he was a senior executive at the company, and so the court and the jury were essentially kind of calculating, what did he lose? What did this individual lose from losing his position? There was also an initial finding of a punitive damages award, which is, if a court or jury finds that there was a willful or malicious violation of the law, they can award extra damages to sort of, deter the company from making those, alleged violations in the future. Here, the $3.8 million judgment was upheld. The appeals court said that there wasn't enough evidence to show that it was a willful violation or a malicious or intentional violation. So part of the punitive damages or the punitive damages were cut. But again, a substantial verdict, and I put this one in because it's kind of a demonstration of how these cases are starting to pop up in kind of the individual employment context. When an individual doesn't get a promotion or is terminated, you may be considering different forms of discrimination complaints, and this Duval case is a recent example under Title VII. So one other Title VII case of note, again, you can tell, one thing that's kind of uncommon in this area as compared to some of these presentations that you'll hear in the employment context or otherwise, every decision that I've talked about today is within the last few months. You know, all these cases are 2024 decisions, recent. It's very much an emerging area of law, which is one of the reasons, you know, so many of our clients, of organizations, like your organizations, are trying to keep up with what's happening out there. So this was, again, another federal appeals court decision, so the highest courts just below the Supreme Court in the federal judicial system. This was a case that involved DEI training. So the DEI inclusion and training programs that are common at organizations, at employers. And the individual here was employed by the Colorado Department of Corrections. So they were a state government employee. And the allegation was that the individual was subject to a hostile workplace because of the required DEI training. Hostile workplace is a concept under Title VII. It's a little different than the concept we talked about at the beginning. You know, the idea at the beginning is, you know, when you make an employment decision, or you know, some of the other concepts about training programs or otherwise, that, you know, you can't make decisions on the basis of race or gender. You know, there's a kind of a specific discrete act. There was a hiring decision, and there, you know, was an allegation that race was part of the hiring decision. Hostile work environment claims are about a more sort of sustained, less concrete period of time in a workplace. So the classic example under Title VII is if there's an individual who's subject to sustained sexual harassment over a period of 2 years, or, you know, race-based harassment over a period of 6 months, and, you know, their supervisor is making discriminatory comments, or you know, it could be a variety of things, but the idea in each of them is that a hostile workplace exists if there is a severe and pervasive sort of environment that is, you know, subject to race or sex or religious-based discrimination. So the individual here said, you know, by simple virtue of being required to complete DEI training, I was subject to a hostile workplace. The court said no, that the employee had failed to demonstrate that the DEI training program created a hostile workplace. But there was cautionary language, and the cautionary language, I think, caught a fair amount of attention from practitioners in this area, and, you know, employers and otherwise. And what the court in this case did is to say, look, the employee here hasn't shown that, you know, that the employee was subject to a hostile workplace, but when we, the court, look at the specific content of this DEI training program, we see, and they quote some language here that I put on the slide, some racial subject matter and ideological messaging in the training materials that the court says was, quote, troubling. And they say that, you know, the presentation was not itself sufficient to create a hostile workplace, but it sets the stage for actionable misconduct. And to sort of spell that out a little, what the court was really focused on was, and we've seen this in some other cases, including there was a case involving Penn State University and a professor there who brought a similar claim. The court's really focused on sweeping generalizations on the basis of race, so sweeping negative generalizations. So in these cases that have sort of caught the court's attention, you know, it's not typically been the, you know, a PowerPoint that's focused on, you know, inclusion alone, you know, on non-discrimination alone. There's typically some alleged content, you know, all white male professors are bad, or, you know, something like that, that's really, in the eyes of the court, potentially sweeping, and a sweeping generalization that is based on race. The court in this case thought that there was some of that here. You know, they said that the individual employee hadn't shown that because of the, you know, the messaging in the PowerPoint that he had been subject to, you know, any harassing comments by a coworker or any negative treatment by a supervisor, but the messaging was essentially kind of a subject of a cautionary tale from the court. And I think the real kind of takeaway from this case and from that Penn State case I mentioned is, it's worth looking at kind of the specific content of DEI training PowerPoints or materials, really with an eye on the, are there sweeping generalizations or potentially, sweeping generalizations that are based on race? If so, those are the things that are catching the attention of some of these courts. Again, the idea of this case is not by any means that inclusion training generally is unlawful, but rather that there's a particular kind of somewhat newfound, I think, attention to very specific content in these training programs.
Hey, Tristan, I just want to quickly jump in with a question.
Sure.
Someone asked about the Duval case. How relevant was it that the materials related to diversity targets were publicly available versus shared internally?
It's a good question. I mean, I think that in that case, because it got to trial, kind of everything came out, right? I mean, and it's something to keep in mind, as you would with any time there's an employee that, you're terminating an employee, or there's a major employment, decision, and you're considering as an employer, as an organization, could we get a claim here that this was based on, gender or based on race? And you want to think through, what would the materials actually show? Would they show that, we've documented performance issues with this employee? We gave this employee a warning about, their performance or about some misconduct, or would it be more of a murky, record, and everything would have to be kind of explained by witness testimony? That's something kind of always you're thinking ahead a little bit as an organization or an employer. In the Duval case, because it got to a full trial, it was everyone telling their full story, right? The company had to put up their witnesses. Who made the employment decision? What did they tell Duval at the time he was fired? What did they tell the person who got the job? What did they tell, there was some testimony about what were they telling recruiters who were interested in potentially hiring Duval for his next position? What did they explain to be the reason that he was separated? And all of that kind of more detailed testimony was paired with what was probably known, kind of right off the bat, which is, okay, we went to the website for this company, Novant, and, as the plaintiffs, we pulled the language about, their DEI goals for senior leadership. What I would say that, is very common is in these complaints that get filed, any of these complaints that we've talked about today and a host of others, it's very common to see in the complaint, here's the language from the ESG report for the company. Here's the language about what the company has described as their goals for, their board of directors or their senior leadership, and those can be pulled off the website. Those are the first thing often that, you see cited as evidence in a complaint. But it's important, I think the Duval case is an important reminder that, in the event, which is pretty rare, but in the event that a case like this gets actually litigated, and put before a jury or a judge, the emails and stuff about what was going on at the time, all of that can come out, and it's all kind of factored into an assessment of, what was actually the motivating factor for the employment decision, and does it match up with what the employee was being told at the time? Does it match up with what the employer has argued in this case, was the basis for their action, or does it tell us that, maybe there was more uncertainty or anything like that?
Great, thank you.
Sure. So those are the cases. I think going back to this slide that we started with, you kind of see, I think, a little bit of each of these sort of at play in some of these cases. And I think that one thing, I mean, the Duval case shows, for example, is that oftentimes these complaints are sort of pulling from different of these categories, right? So the Duval case is a hiring, firing case, but the plaintiff was pulling in evidence about race and gender-based goals for leadership, and how did that inform the alleged hiring decision? But these are kind of the things that are getting the most attention, I think, in the legal landscape. And I think it's important. This last question, about public materials versus internal, I think is actually a good place to kind of close. And as Daryl said, today's discussion is sort of a broad overview of the legal landscape. What are we seeing in terms of what complaints are being filed and what early decisions are being set out? And it's not a let's look at your specific policies and talk about how you might consider your legal risk or your adjustment to eligibility. But one thing that is broadly true for any organization is it's worth sort of auditing your own materials at this point, and you can do it with legal counsel, certainly if you have counsel available to you, but looking at what your own policies are, and starting with what's out there publicly, right? If someone were looking at your organization, whether it's a grant program or a hiring, a job posting, what would they find if they went to your website? Look at that internally to see what's out there. And one of the reasons I suggest that is not only to sort of make sure what's out there and what your legal risks might be, mapping onto some of these concepts that we've talked about today, but also to make sure that you're making an informed decision about what you would kind of be defending if you're subject to one of these claims, right? You don't want to be in a position where there's a claim that one of your policies is impermissible under one of the concepts we talked about today, when maybe it's not even actually part of your hiring criteria or your grant making criteria. Maybe the eligibility criteria has changed, but there's something up on the website that doesn't reflect that change. So I think there's a lot of benefit in looking at your own materials, looking at them with an eye on how does it map onto these legal risks, but also just making sure that it maps onto kind of your own understanding of what's out there. A couple of last points here. Hiring, promotion, I mean, just to get a sense for what some of these concepts are, I've got two examples here in the wide range of what falls in the hiring and promotion bucket. Pipeline expansion is a very common when there's discussion about DEI programs, and this can be things like increasing awareness of opportunities, right? If you're in the construction business and you want to increase awareness of opportunities in the construction business or in the engineering business or the airline business or higher education, just increasing awareness. Hey, there are these opportunities. If you want to come work at our organization as a new hire, we're looking to increase our outreach and to expand the applicant pool, expand the number of people who are considering coming to work for our organization. That is generally a very low risk proposition. You're working to increase the pool of applicants. It's important that that be tied to the idea that in the selection process, the candidates be selected on the basis of the candidate best qualified for the position, not on the basis of race and gender. But pipeline expansion is an example of what's typically a very kind of low risk means of diversifying applicant pools. It's an employment concept often, but it is very similar in terms of its application and the kind of consideration it's getting, even in the non-employment, in the contracting context, right? That if you're offering grants, that there may be a very similar focus on getting the word out, expanding awareness of the work that your organization is doing, expanding awareness of opportunities, and then using that to sort of aim to expand the pool of applicants, to make it a widely inclusive pool of applicants for your organization, paired with the idea that the selection process would be based on the candidate best qualified for the position, not on the basis of race and gender. But I think that, maybe I'll close with that point, because I think it highlights that the best practices in the employment context are in many ways the same best practices that are applicable in, what we've talked about as the contracts context today under Section 1981, the idea of partnerships or supplier agreements or vendor agreements. The best practices, I think, are generally quite similar in a number of respects in both of those contexts. With that, I think it's 1 o'clock, and really appreciate everyone's time today. Daryl, thank you. Lauren, thank you, and appreciate the opportunity to be here with everyone.
Tristan, thanks so much for doing this. I think we had a couple questions that I think you actually got to in your closing remarks. Folks were looking at sort of, what's the likelihood that board diversity as a goal is permissible, and I think there's certainly there's a means by which that's allowable depending upon how it's presented, and I would think a lot of what you were looking at in the hiring context certainly discusses that as well. Again, thank you so much for doing this. I hope we get to have some more discussions, because I know there's a lot of folks who are going to be really interested in this conversation. There's, of course, as this legal landscape changes, I'm sure there'll be need for more discussion moving into the future. Just want to let everyone know who's participating right now. You'll get a pop-up to a survey that I hope you'll be able to respond to, and obviously speak highly of all of Tristan's great helpful information. Again, pleasure being with all of you, and hope to see you soon. Take care.
Thanks, everyone.